Good afternoon, and greetings from Budapest for those who are online and who are on site as well. And I'm very honored to be here and make this short intervention. And thanks the organizers and the Raluca for having me. And my presentation, I was thinking about what to be the framework for my presentation to make it, to have a special approach to make it interesting. And the issue I'm dealing with nowadays is the resilience of the legal system, of the institutions and the actors in Hungary. And I try to put this question into this framework. And I'm trying to move my slides. Do they move? So can you see the outline? Okay, great. So the structure I would go with is that first talk very briefly about the political and legal context in which the issue of the lawyers' freedom of expression occurs in Hungary, and it will cover two issues: the rule of law breakdown that's now going on more than a decade, and some preliminary research on the low level of resilience of the Hungarian institutions, including the legal profession as such. And then I will discuss two cases, which the thing that is common in them, that they are covering the question of what is the scope of the legitimate criticism of judges and the judiciary by lawyers. One case is a defamation case, and the other one is a disciplinary proceeding. The defamation case shows how the courts and the judges understand the scope of the lawyer's freedom of expression, and the disciplinary proceedings is about how the bar itself understands this. And I will make a quick reference to how these cases and reasonings includes or fail to include European standards, which I also think an important factor to make the capacity or the ability of the institutions to resist attacks and the backsliding of the rule of law. And then I would conclude with some questions or reflections on the role of lawyers and the resilience of the rule of law in Hungary. And I will be quick with the first part, because I know that everybody is familiar with what has been going on in Hungary now for years, with the dismantling of the checks and balances and the changes since 2010 in the constitutional and legal order that also affected badly the judiciary as well. And this is just a very recent report on the status of rule of law in Hungary, where you can see that Hungary performs very badly in terms of the indicators that the World Justice Project use. You can see here that there are 8 factors or indicators that are measured when this index is made. And if I just go back, you can see that Hungary is the 73rd out of the more than 140 countries. And so there is a general decline in the rule of law. And there are some research on the resilience of the rule of law and the institutions in EU member states. And if we just look at this picture, we can see that Hungary is among the countries. I think it's not something that is surprising for us, but Hungary is among the countries that shows quite low level of resilience, or a weak resilience towards the attacks on its institutions and the rule of law. And my question is that how the cases on lawyers' freedom of expression and how the approaches of the court and the bar affect the resilience of the legal profession, specifically the judiciary and the lawyers themselves. And I would speak briefly with 2 cases. The first one is a criminal procedure when the freedom of expression issue came out outside of the courtroom. And in this case, a criminal proceeding were instituted against the lawyer for Facebook posts. And these posts were made in a public Facebook page, which have a large number of followers, and normally triggers intensive debate and exchange of views. And in this case, the lawyer appeared as a respondent as a representative of the respondent, and made criticism of a particular judge who heard his case, mainly for ignoring the case law of the Court of Justice, the Court of Justice of the EU. And these Facebook posts were made just, the first one is right after the delivery of the judgment, claiming that the judge actually ignored the case law of the Court of Justice or failed to apply the law, and this was the main reason for dismissing the complaint of the respondent. And the second Facebook post was made a few weeks later, when the drafted and written and finalized judgment were sent to the attorney. And while in the first case, the Facebook post indicated and named the judge specifically, the second did not make any reference to the judge himself, however, contained some critical statements. And just to go to the decision, the court found that the lawyer with his posts published on a public Facebook site committed the criminal offense of defamation, and he was sentenced to a fine. And I brought also a table regarding the main arguments, the main statements that was called into question in this case, and the assessment of the court. And just to give you some gist, okay, what these statements were about. The lawyer on his post claimed that the judge rejected the complaint by admitting that he was not familiar with the Court of Justice jurisprudence, and when claiming that these decisions that were referred to by the lawyer did not affect the dispute. So this was one of the claims that was contested. There were claims about the judge himself and his previous activity at the Metropolitan Court, and the fifth one was interesting because after receiving the transcript of the hearing, the lawyers saw that it is in the transcript that some swear words were made by him when he was leaving the courtroom, and he contested this as well. And those statements and assessments that are in red lead to the criminal conviction of the judge by the court, claiming that these statements accused the judge of deliberately ignoring the application of the Court of Justice jurisprudence, the specific decisions, and they were capable of suggesting for the audience that the judge is incompetent and acted in an arbitrary way, and such activities that the judge was accused of could raise professional and ethical concerns, which is unacceptable. And the court also highlighted that as judges are not capable of defend themselves, as they are restricted in commenting on individual cases, the lawyer should show a duty of restraint in criticizing, or the way how they criticizing the activity of the judge in a specific case. Okay, so the first case was a criminal conviction. The second one was a disciplinary proceeding. When the statements were made within a judicial proceeding, so within a court proceeding. In this case, the disciplinary proceeding was opened against the lawyer on the basis of a complaint that was made by the court president, that in one of the submissions, the lawyer made critical statement about the independence of the judiciary in general, and criticize the case law of the judiciary for its failure to be compatible with EU law as well. And in this case, the bar and the first instance board of the bar, the disciplinary board, found no violation of rules of conduct. However, the disciplinary proceedings were opened and there were investigations against the lawyer. And the main argument was that for not finding a breach of any kind of rules of conduct by the lawyer with these statements in the submission, in the written submission, were that the statements that were in question were general and generally targeted the judiciary, and it did not aimed at a particular judge typically. And as it was made in a written submission, it was not public, it was not publicly accessible. Only the parties to the case and the judge was familiar and had any knowledge about these allegations. And the bar had made a very important argument as well. And I would like to highlight again that the whole case originated in a complaint that was made by the court president, that the court president was informed about this submission, and the court president turned to the bar and the regional disciplinary board, claiming that this submission raised concerns, and the statement in this submission can give rise to the disciplinary liability of the lawyer. So it was the court president who made the complaint to the bar. However, the bar claimed that it would be a worrying and tendency if a kind of strong criticism of the judiciary would trigger disciplinary proceedings against the lawyer who is acting, however, in the best interest of the client, because these statements and this criticism towards the independence and impartiality of the judiciary in general and the correctness of the jurisprudence of the court was made in the interest of his client as part of a procedure. And the bar claimed that the Hungarian Bar Association guarantees freedom of belief, speech, conscience, and expression, and the restriction of freedom of expression, and which also entails some kind of restriction on the independence of the bar by disciplinary proceedings or the imposition of a disciplinary sanctions as a consequence of any strong criticism would be unacceptable. And this was an important argument made by the bar in this disciplinary case. And to compare the two cases quickly, I'm just looking at the time, okay, I have to move forward. We can see that there are differences, clear differences in the cases, because the criminal proceeding covered statements that were made on Facebook, however, the disciplinary proceedings were about statements that were made in a court proceeding, in a written submission. The Facebook post directed at an individual judge. However, the submission and the critiques in this written submission targeted the judiciary in general, which can be, I think, important. And now perhaps I turn to the question, okay, how these cases and the arguments and the results of these cases affect or have any impact on the resilience of the legal profession, either on the judiciary and the resilience of the judiciary or the resilience of the lawyers. What is important to highlight is that if we look at the defamation case, we can see that the finding is likely to narrow down the freedom of expression of lawyers by imposing on them criminal sanctions for criticizing the judiciary and the administration of justice. Second, if the judiciary is likely to shield itself from public criticism, it can also lower the capacity of the judiciary to withstand pressure, because it can also have a kind of repercussion on the freedom of speech of judges as well. Because in that case, if we if the judiciary is not part and the activity or the administration of justice is not part or cannot be part of the public discourse, it's even difficult for judges to speak up and raise their voices and voice their criticism on the problems of judicial independence as well. The third issue which should be highlighted, which is not just based on the specific judgment, but the general insight of the TRIIAL project, is that the Hungarian courts are reluctant to engage genuinely and substantively with European jurisprudence. So if we go back to the previous slide, we can see that in the criminal proceeding that was decided by the courts, there were no direct reference to the Court of Justice case law, which is very extensive. And there is an evolving case law on the freedom of expression of lawyers. However, the judge simply made general statements regarding the standards of the Court of Justice and mostly relied on the national case law, the judgment of the Constitutional Court and the Supreme Court. There were some references in the disciplinary proceedings made by the disciplinary board of the bar. However, these references regarding the Nucula case or a Moldovan case, they are quite old cases, and there are no reference to the new recent cases. And it is a general question whether the lack of engagement of the European jurisprudence specific to the Strasbourg standard can again weaken the resilience of the judiciary. And the second issue regarding disciplinary case, and I will conclude with that it's a positive result of the disciplinary judgment that the bar claimed that it would be unacceptable if courts are challenging the freedom of expression of lawyers by initiating disciplinary procedures, and this trend should be somehow blocked. However, the simple fact that the disciplinary proceedings were opened against this lawyer can have a chilling effect and can silence judges who are otherwise would address a kind of legitimate criticism toward how the judiciary functions. And one extra note, that the debated statements concern the independence of the judiciary and a general problem of Hungarian courts failing to comply with EU law, addressing EU law and CGU judgments. And these are those statements that are not unreasonable, and they have legal basis and factual basis. So it's a problem if such criticism, which seems to be remaining in a professional scope, are stifled by disciplinary proceedings or criminal sanctions. So this would be the major conclusions, but they are just very tentative ideas how these issues affect the resilience and the law resilience, or how they explain the law resilience of the judiciary and the legal profession in general. So thank you for the attention, and sorry for being a little bit longer than I promised.
Thank you very much.